शुरू करो. Hello everyone. We have seen the powers of the appellate court and we have discussed in detail what are the different powers under the CPC. Now, whether the appellate court, when the case comes for appeal, has complete powers, whether it can do whatever it likes. Here, every power is also combined with a duty. We know that. So, the powers of the High Court also consist of duties of the High Court. So, what are the duties and whether the duties are all stated in the CPC or whether the duties are followed or how the cases show what is the duty of the appellate court, that is the subject which we are going to discuss today, and also what is the form of the judgment and decree of the appellate court. We have seen the judgment and decree of the in the suit. Now, in appeal, what is the difference and whether there is a requirement under the law. These are the conditions which we are going to look into today. ಒಂದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಒಂದು ಪವರ್ ಇದೆ ಅಂತ ಹೇಳುವಾಗ ಆ ಅಧಿಕಾರ ಜೊತೆಯಲ್ಲಿ ಕರ್ತವ್ಯಗಳನ್ನು ಸೇರಿರುತ್ತೆ. ಆ ಕರ್ತವ್ಯಗಳು ಏನು ಅಂತ ಹೇಳಿ ನಾವು ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಿ. ಮತ್ತು ಜಜ್ಮೆಂಟ್ ಮತ್ತು ಡಿಕ್ರಿ ಯಾವ ರೀತಿ ಬರುತ್ತೆ ಅದನ್ನು ನಾವು ಇವತ್ತು ಈ ಸೆಷನಲ್ಲಿ ನೋಡೋಣ. First of all, when we speak about the duties of the appellate court, we can say that, just a moment, we can say that the duties of the appellate court are such that it controls the powers, that is, the powers are not absolute, the powers are not uncontrolled, and the court has to decide appeals keeping in mind all the duties imposed by the Civil Procedure Code. Even the appellate court has to look into these duties. Now, what are these duties? We can classify in this manner. First of all, there is a duty to decide appeal finally, not interfere with the decree for technical errors, reappreciate evidence, to record reasons and other duties. ಸೊ ಒಂದು ಅಪೀಲ್ ಬಂದಾಗ ಅದನ್ನು ಕೊನೆಗೊಳಿಸೋದು. ಎರಡನೇದಾಗಿ ಯಾವುದೇ ಟೆಕ್ನಿಕಲ್ ಎರರ್ಗೋಸ್ಕರ ಟೆಕ್ನಿಕಲ್ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದ್ರಿಂದ ಡಿಕ್ರಿಯನ್ನು ಚೇಂಜ್ ಮಾಡೋದು ಅವರ ಕರ್ತವ್ಯ ಅಲ್ಲ. ಮತ್ತು ಯಾವುದೇ ಎವಿಡೆನ್ಸ್ ಬಂದಾಗ ಆ ಎವಿಡೆನ್ಸನ್ನು ಸಾಕ್ಷಿನ ಸರಿಯಾಗಿ ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಬೇಕು, ಸರಿಯಾಗಿ ನೋಡಬೇಕು. ಮತ್ತು ಯಾವ ಡಿಸಿಷನ್ ಕೊಡ್ತಾರೆ, ಯಾವ ನಿರ್ಣಯ ಕೊಡ್ತಾರೆ ಅದಕ್ಕೆ ಒಂದು ರೀಸನ್ನ, ಕಾರಣನ ರೆಕಾರ್ಡ್ ಮಾಡಬೇಕು. ಮತ್ತು ಅದ್ರ ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಡ್ಯೂಟೀಸು ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಜಜ್ಮೆಂಟ್ಸ್ ನಾವು ನೋಡಿದ್ವಿ ಅಂತಾದರೂ ನಾವು ಡಿಸ್ಕಸ್ ಮಾಡೋಣ. ನಾವು ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಟು ಡಿಸೈಡ್ ದ ಅಪೀಲ್ ಫೈನಲಿ, ವಾಟ್ ಈಸ್ ದಿಸ್ ಡ್ಯೂಟಿ? ಸಿ, ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ವೆನ್ ಎ ಅಪೀಲ್ ಕಮ್ಸ್ ಟು ಇಟ್ should decide the appeal in accordance with the law after considering the evidence as a whole. Andre, see, the appeal is always decided according to law. The facts are not interfered with by the appellate court. That is a general rule. ಯಾವುದೇ ಕಾರಣದಲ್ಲಿ ಒಂದು ಫ್ಯಾಕ್ಟ್, ಒಂದು ಸಂಗತಿಯ ಪ್ರಶ್ನೆ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಮತ್ತೆ ರಿಓಪನ್ ಮಾಡಲ್ಲ. ಸಂಗತಿ, ಎಲ್ಲ ಸಂಗತಿಗಳು ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ನಿಶ್ಚಿತ ಆಗಿರುತ್ತೆ. ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಕಾನೂನು ಪ್ರಕಾರ ಇದನ್ನು ಮಾಡಬಹುದಾ ಇಲ್ಲ ಅಂತ ಅದನ್ನು ಮಾತ್ರ ಕನ್ಸಿಡರ್ ಮಾಡುತ್ತೆ. ಆ್ಯಸ್ ಅ ಹೋಲ್ ಇಟ್ ವಿಲ್ ಡಿಸೈಡ್ ದ ಅಪೀಲ್. ಸೊ ಇಂಥ ಏನಾದರೂ ಕ್ಲಿಯರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಇದ್ದಾಗ ಅದರ ಕರ್ತವ್ಯ ಏನು ಅಂತಂದರೆ ಫೈನಲಿ ಕೊನೆಗೊಳಿಸಬೇಕು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಡಿಸೈಡ್ ದ ಕೇಸ್ ಫೈನಲಿ. ದ ಜಜ್ಮೆಂಟ್, ವೆನ್ ಯು ಸಿ ದ ಜಜ್ಮೆಂಟ್ ಆಫ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್, ಇಟ್ ಶುಡ್ ಕ್ಲಿಯರ್ಲಿ ಶೋ ದ್ಯಾಟ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅಪ್ಲೈಡ್ ಇಟ್ಸ್ ಮೈಂಡ್ ಟು ದ ಹೋಲ್ ಆಫ್ ದ ಎವಿಡೆನ್ಸ್. ಎವಿಡೆನ್ಸ್ನ ನೋಡಬೇಕು, ಎವಿಡೆನ್ಸ್ ನೋಡಿ ಅದರ ಬೇಸಿಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಬೇಕು. ದೆರ್ ಇಸ್ ಒನ್ ಕೇಸ್, ಸ್ಟೇಟ್ ಆಫ್ ತಮಿಳ್ನಾಡು ವರ್ಸಸ್ T.N. ಕುಮಾರಸ್ವಾಮಿ, All India Reporter 1977. There the suit was for declaration of title on a land. It was decreed by the trial court. ಒಂದು ಲ್ಯಾಂಡ್ ಮೇಲೆ ಟೈಟಲ್ ಸ್ವಾಮಿತ್ವ ಮೇಲೆ ಒಂದು ಕೇಸ್ ಇತ್ತು, ಅದನ್ನು ಡಿಕ್ರಿ ಮಾಡಿದ್ರು. ಡಿಕ್ರಿ ಮಾಡಿದ ಮೇಲೆ ಅಪೀಲ್ಗೆ ಹೋಗ್ತಾರೆ. ಈ ಗೋಸ್ ಇನ್ ಅಪೀಲ್. Now here the High Court remanded the suit for finding on two issues. ಎರಡು ಇಶ್ಯೂಸಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಮಾಡಿ ನೀವು ಇನ್ನೊಂದು ಸತಿ ಅದನ್ನು ಫೈಂಡಿಂಗ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ. ರಿಮಾಂಡ್ ಆಗುತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ. ಸೊ ದಟ್ ಈಸ್ whether plaintiff has title to the suit properties, number 1, whether respondent has possession. The plaintiff, if he has a title, whether the respondent has a possession. Now, these things were already looked into by the trial court, but the High Court says that it is not easy to believe what has been recorded by the trial court, and they should once again look into the matter and send the evidence or take the evidence. Now, this was these two findings, whatever was stated, on that finding, the Supreme Court, the subordinate court judge says that there is no possession and there is no title. Title illa, possession illa anta findings barutte. Next adu change agutte. So then he goes in appeal before the Supreme Court. Now, the Supreme Court says that once the findings were given by the trial court, they cannot be brushed aside by the appellate court. ಒಂದು ಅಪೀಲ್ ಕೋರ್ಟ್ ಒಂದು ಫೈಂಡಿಂಗ್ ಕೆಳಕೋರ್ಟ್ ಕೊಟ್ಟಿದೆ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಆ ಫೈಂಡಿಂಗ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಬಿಕಾಸ್ once the case goes on before the trial court, what happens is all the witnesses come before the trial court, the documents are appreciated by the trial court, in detail the evidence is looked into. The appellate court does not have that advantage of calling the parties and taking the evidence. So, it must normally, it should believe the findings of the trial court. Unless there is a question, unless there is a point of law, it should not interfere in the trial court's findings. So, here the Supreme Court said that the appellate court has not exercised its duty to decide the appeal finally when it came before it, and then the appeal was allowed. ಸೊ ಇದರಲ್ಲಿ ತನ್ನ ಕರ್ತವ್ಯನ ಸರಿಯಾಗಿ ನಿರ್ವಹಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅಪೀಲ್ ಅಲೌ ಮಾಡಿ ಮತ್ತೆ ರಿಮಾಂಡ್ ಕಳಿಸಿ ಅದನ್ನು ಸರಿಯಾಗಿ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಗೆ ಕಳಿಸ್ತಾರೆ. ಸೊ ದಿಸ್ ಇಸ್ ಎ ಡ್ಯೂಟಿ ಟು ಡಿಸೈಡ್ ಅಪೀಲ್ ಫೈನಲಿ. ನೆಕ್ಸ್ಟ್, not interfere, the duty to not interfere with the decree for technical errors. If there is any technical error, for example, if the person who files the case has not paid the court fees, or there is a territorial jurisdiction question, any technical error which has been committed by the trial court should not be interfered with when the appellate court passes the decree or looks into the case, unless it is on merits. Unless it is not on merits, it has not been done on merits. So, the decree which is on merits, ಪೂರ್ತಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ತಗೊಂಡು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದನ್ನು ಡಿಕ್ರಿ ಮಾಡಿದ್ಮೇಲೆ it is within the jurisdiction of the court has jurisdiction to pass that particular judgment, that such a judgment shall not be reversed or substantially varied by the appellate court. Appellate court does not have the duty to do so. It has a duty to look into the case as it has been decided by the trial court. It cannot remand for any technical error, for example, misjoinder of parties, misjoinder of causes of action, or any irregularity in the proceedings ಸರಿಯಾಗಿ ಆಗಲಿಲ್ಲ ಅಥವಾ ಕ್ರಮ ಬಿಟ್ಟು ಅದನ್ನು ತಗೊಂಡಿದ್ದಾರೆ ಅಥವಾ ಯಾವುದೇ ಪಾರ್ಟೀಸ್ ಮಿಸ್ಜಾಯಿಂಡರ್ ಆಗಿದ್ದಾರೆ, ಅಂಥ ಟೆಕ್ನಿಕಲ್ ಎರರ್ಸ್ಗೆ ಡಿಕ್ರಿಯನ್ನು ರಿವರ್ಸ್ ಮಾಡಬಾರ್ದು. This is a provision in section 99 of the CPC. It clearly says that a case cannot be remanded for technical errors. So, to prevent technicalities, what is the object? ಏನಕ್ಕೆ ಅಂತ ಇದು ಟೆಕ್ನಿಕಲ್ ಎರರ್ಸ್ ನಾವು ನೋಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತೀವಿ ಅಂದರೆ, ಇದು ನ್ಯಾಯಕ್ಕೆ ಮೊದಲನೇದಾಗಿ ಸಬ್ಸ್ಟ್ಯಾನ್ಷಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇಕು. ಅದನ್ನು ಏನು ಮೂಲಭೂತ ಏನು ಸಂಗತಿಗಳಿದೆ ಅದನ್ನು ನೋಡಬೇಕು. ಟೆಕ್ನಿಕ್ಯಾಲಿಟೀಸ್ ದೇ ಆರ್ ಓನ್ಲಿ ಫಾರ್ ಪ್ರೊಸೀಜರ್ ಪರ್ಪಸಸ್, ಟು ಸಿ ದಟ್ ದೇ ಅಪ್ರೋಚ್ ದ ಕೋರ್ಟ್ಸ್ ಅಂಡ್ ದೇ ಗೆಟ್ ದ ಜಸ್ಟಿಸ್. ಸೊ ದೇ ಪ್ರಿವೆಂಟ್ ದ ಟೆಕ್ನಿಕ್ಯಾಲಿಟೀಸ್ ಫ್ರಮ್ ಆಪರೇಟಿಂಗ್ ಆಸ್ ಅ ಮೀನ್ಸ್ ಆಫ್ ಸರ್ಕಿಟ್ರಿ ಆಫ್ ಲಿಟಿಗೇಷನ್. ಇದು ಟೆಕ್ನಿಕ್ಯಾಲಿಟಿಯಿಂದ ಡಿಕ್ರಿ ರಿವರ್ಸ್ ಮಾಡ್ತಾ ಹೋದರೆ ಇದು ಲಿಟಿಗೇಷನ್ ಹಾಗೆಯೇ ಸರ್ಕಲ್ ಹೋಗ್ತಾ ಹೋಗುತ್ತೆ. ಇಟ್ ಗೋಸ್ ಆನ್ ಕಂಟಿನ್ಯೂಯಿಂಗ್. ದರ್ ಇಸ್ ಒನ್ ಕೇಸ್ ವಿಚ್ ವಿ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಕಸ್ಡ್ earlier, Kiran Singh versus Chaman Paswan. I think you remember that. That is in 1954. Kiran Singh and versus Chaman Paswan is a case where a person files a case before he files a suit in Mongir, in the area of Mongir, for recovery of land, and there the defendants are the proprietors of the land. This suit was valued for according to the suit fee, that is Court Fee Valuation Act. There is an act for valuation of the suit. So he pays the valuation amount. Then the suit was dismissed. Then he goes to the district court. When he goes to the district court, in the first appeal, that is in the first appeal he goes to the district court, the district court also dismisses it. Okay. Then he goes saying that he does not have a right on that land. Then he goes in appeal to the in the second appeal to the High Court. Here in the second appeal he puts forward a contention that, see, at that time what happens when he is filing before the High Court, the court reporter who values the suit, he says that there is a mistake, there is a technical error here, because whatever court fees you have paid in this is less. So you have to pay the extra court fees. So he pays the extra court fees. Now what happens, if he pays the extra court fees, the jurisdiction, pecuniary jurisdiction of the district court is not there. He should have come directly to the High Court if that was valued for that amount. So what he says is, he contends that the district court's judgment should be taken as null and void, and it should be not taken that it is a second appeal. This should be taken as a first appeal only, because in the second appeal there are different reasons to take up. First appeal, the court can look into the whole thing, like the evidence and everything, but in the second appeal only on substantial law question of law it can look into. So the court he contends before the court that it should be taken as a first appeal, not as a second appeal. ಇದು ಟೆಕ್ನಿಕಲ್, ಅವನ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡಿರೋದ್ರಿಂದ ಅವನು ಜಾಸ್ತಿ ಫೀಸ್ ಕಟ್ತಾನೆ. ನೆಕ್ಸ್ಟ್ ಅವನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಇದರಲ್ಲಿ ಹೋಗಬೇಕಾಗಿಲ್ಲ, ಅವನು ಅಷ್ಟು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿದರೆ ಮುಂಚೆ. ಅದಕ್ಕೆ ಅವನು ಏನು ಕಂಟೆನ್ಷನ್ ಮಾಡ್ತಾನಂದರೆ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಏನು ನನ್ನ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಫಸ್ಟ್ ಅಪೀಲಲ್ಲಿ, ಅದನ್ನು ತೆಗೆದುಹಾಕಬೇಕು, ಮತ್ತು ಫಸ್ಟ್ ಅಪೀಲ್ ಅಂತಾನೆ ಈ ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಇರೋ ಅಂಥ ಜಜ್ಮೆಂಟ್ ಇರೋ ಅಂಥ ಸೂಟನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ. ಹಿಯರ್ ದ ಕೋರ್ಟ್ ಸೇಸ್ ದ್ಯಾಟ್ ದ ಸೂಟ್ whenever, just because of the the valuation of the suit, it is a technical error, and because of that it cannot overcome the ends of justice. Therefore the judgment of the district court cannot be ignored. So ಅದನ್ನು ಇಗ್ನೋರ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಇದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಂತಲೇ ತಗೋಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ. ಸೊ ದಿಸ್ ಕಂಟೆನ್ಷನ್ ಕೆನಾಟ್ ಬಿ ರೇಸ್ಡ್ ಎಟ್ ಆಲ್ ಒನ್ಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ದ ಸೂಟ್ ಇಸ್ ಡಿಸೈಡೆಡ್. ಓಕೆ, ಸೊ ದಟ್ ಈಸ್ ಹೌ ಟೆಕ್ನಿಕ್ಯಾಲಿಟೀಸ್ ಗ್ರೌಂಡಲ್ಲಿ ಅಥವಾ ಯಾವುದೇ ಒಂದು ಕ್ರಮ ಫಾಲೋ ಮಾಡಿಲ್ಲ ಅಂತ ಗ್ರೌಂಡಲ್ಲಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ನಿರ್ಣಯ ತಗೋಬಾರ್ದು ಅಂತ ಅದು ಕರ್ತವ್ಯ ಇದೆ ಅಂತ ನಾವು ನೋಡ್ತೀವಿ. ಥರ್ಡ್ ಈಸ್ it has a duty to reappreciate the evidence. So whatever evidence has been taken by the trial court, it is presented before the appellate court. Reappreciate does not mean to take additional evidence. Don't confuse the two. That is, reappreciate means whatever the view has been taken by the trial court, that it will look into. The appellate court will see that whatever findings are recorded by the trial court on the oral evidence of the parties. For example, the witness have come before the trial court. What the trial court has recorded, that the appellate court will look into. And for reversing, if it has to reverse a finding of fact which is recorded by the trial court, there has to be 3 required conditions. ಅದನ್ನು ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿರುವಂಥ ಒಂದು ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ಅದನ್ನು ರಿವರ್ಸ್ ಮಾಡಬೇಕಾದ್ರೆ 3 ಕಂಡೀಷನ್ಸ್ ಇರಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ. This is a case where it says that first thing, it has to apply its mind to the reasons given by the trial court. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೆಳಕೋರ್ಟ್ ಏನು ಕಾರಣ ಕೊಟ್ಟಿದೆ ಅದಕ್ಕೆ ತನ್ನ ಮನಸ್ಸನ್ನು ಉಪಯೋಗಿಸಬೇಕು. ಎರಡನೇದಾಗಿ, ಸೆಕೆಂಡ್ಲಿ, ಇಟ್ ಹ್ಯಾಸ್ ನೋ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ಸೀಯಿಂಗ್ ಆ್ಯಂಡ್ ಹಿಯರಿಂಗ್ ದ ವಿಟ್ನೆಸಸ್. ಸೊ ಅದನ್ನು ಗಮನಕ್ಕೆ ತಗೋಬೇಕು. ನಾವು ಅದನ್ನು ವಿಟ್ನೆಸಸ್ನ ಪ್ರತ್ಯಕ್ಷವಾಗಿ ನೋಡಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೋಡಿದೆ. ದ ಕೋರ್ಟ್ ಶುಡ್ ಬೇರ್ ಇನ್ ಮೈಂಡ್ ದಟ್ ಇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ seen the witnesses, it has not heard the witnesses. Trial court has heard the witnesses. Therefore, the reasons given should be looked into. Then, if it records any cogent and convincing reasons for disagreement with the trial court, suppose ಅದು ನೋಡಿ ಏನಾದರೂ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳಿರುವಂಥ ಫೈಂಡಿಂಗ್ಸ್ ಮೇಲೆ ಏನಾದರೂ ರೀಸನ್ ಕೊಡಬೇಕಾದ್ರೆ, ಏನಾದರೂ ಒಂದು ಡಿಸಗ್ರಿಮೆಂಟ್ ಅದ್ರ ಜೊತೆಲೇ ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಂದರೆ ಒಪ್ಪಿಲ್ಲ ಅದಕ್ಕೆ ಅಂತಂದ್ರಾಗ, ಇದು ಯಾವ ಕಾರಣಕ್ಕೆ ಒಪ್ಪಿಲ್ಲ ಅಂತ ಒಂದು ಕೋಜೆಂಟ್ ರೀಸನ್ ಕೊಡಬೇಕು. ಸಪೋಸ್ ದಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಡಸ್ ನಾಟ್ ಅಗ್ರಿ ವಿತ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಸ್ ರೀಸನ್ಸ್, then it should record its convincing reasons for the same. That is, it has a duty to reappreciate the evidence. There is one case, Madhusudan Das versus Narayana Bai, which is a very interesting case. In this case, a husband files a case for divorce against his wife on the ground of cruelty. She has left him and deserted him, and she is staying somewhere else. Then the case is decided and the trial court decrees it, and the divorce is given. She goes in appeal. When she goes in appeal, the points of evidence which has been stated by the husband, they are not believed by the appellate court. So the appellate court says that the cruelty which he has stated, that she has several acts on her part, what she has done, they cannot be believed, and the reason is not given. They cannot be believed, and therefore it is, that case is dismissed. The divorce case is dismissed, and again the court sends it back. It reverses the decision. Now here he goes to the Supreme Court. The husband goes to the Supreme Court. In the Supreme Court, the court said that the reason which is given by the person is not proper, because if a person if the trial court has already recorded the reasons, you cannot disturb that particular case. So it cannot go back to the facts which it has not seen. There is one more case, Radha Prasad versus Gajadhar Singh, in which the appellate court has reversed the finding of fact. There was a suit of preemption, and in that some ceremonies were to be proved. That ceremonies, how they were done, was recorded by the lower court. The appellate court does not look into that, and the court says that it is not you cannot take up this case, or you cannot take up this evidence as it is, because the fact of the ceremonies what the trial court has recorded cannot be believed as a true. So for that reason it reverses the decision. Here it goes in appeal, and the court says that it cannot, when it cannot be believed, by what is the reason for not believing. So there was it was an absurd point which has been stated by the in this case. Then the duty to record reasons. Whenever a appellate court dismisses an appeal summarily, suppose an appellate court does not call the respondent, as we said, it has the power to dismiss an appeal summarily, and it dismisses the appeal, this power should be exercised sparingly. The duty is that only in exceptional case that a person's liberty is at stake. ತನ್ನ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ನೋಡುವಾಗ, ವ್ಯಕ್ತಿ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ನೋಡುವಾಗ ಇದು ತುಂಬ ಕೇರಿಂದ, ಕಾಳಜಿಯಿಂದ ಡಿಸ್ಕಸ್ ಮಾಡಬೇಕಾಗತ್ತೆ. ಅದರಿಂದ ಇದು ತಗೊಳಕ್ಕಾಗಲ್ಲ ಅಂತ ಈ ರೆಕಾರ್ಡ್ ಮಾಡದೆ, ರೀಸನ್ಸ್ ಕೊಡದೆ ಇದನ್ನು ಏನು ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದ್ರ ಪ್ರಕಾರ ಇದು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿ ಇಟ್ ಒನ್ಸ್ ಅಗೇನ್ looks into the matter. It says that, see, in such cases, whenever there is a duty to record reason, it is very important that the reason should be given. Why reason should be given? That is stated in this case. The thing is, when reason is given, when it comes before the higher court in appeal, on basis of the reasons, the higher court can decide whether the lower court or the trial court or the court which has given the decree has looked into the matter or not. Now he goes in second appeal or in the first appeal. When he goes in appeal, if the lower court has not recorded reasons, the higher court is not able to look into the fact whether the lower court has applied its mind or not. ಅದನ್ನು ಲೋವರ್ ಕೋರ್ಟ್ ತನ್ನ ಮನಸ್ಸನ್ನು ಉಪಯೋಗಿಸಿದೆಯೋ ಇಲ್ಲವೋ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಆಗ ಅಪೀಲ್ ಡಿಸೈಡ್ ಮಾಡೋಕ್ಕಾಗೋದಿಲ್ಲ. ಸೊ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೆಂಟ್ ಬ್ಯಾಕ್. ಮತ್ತೆ ಅದನ್ನು ನಿಮ್ಮ ಮನಸ್ಸು ಉಪಯೋಗಿಸಿ ಅಂತ ಕಳಿಸ್ಬೇಕಾಗತ್ತೆ. ಸೊ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್, ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಕ್ಲಿಯರ್, ಇದನ್ನು ರೆಕಾರ್ಡ್ ರೀಸನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ. ಸೊ ಇನ್ ಸಚ್ ಕೇಸಸ್, ಇನ್ ಬೋತ್ ದೀಸ್ ಕೇಸಸ್, it has been stated by the Supreme Court that it is a duty of a appellate court to record the reasons. There is one more case, that is where a person was adopted and his father died, creating a trust. So before that, when it was a trust was created, the person, that is the adopted son, he questioned the adoption, he questioned the trust, saying that it is void because I am the son, I have a share in the property. Now that finding which was there, for that there was no reasons recorded, and the court was the suit was decreed. He went to appeal, and then the trustees go to appeal before the High Court. High Court reverses the decision, taking different view of the evidence on record. Whatever the reasons were given relating to the adoption, they changed it and they reversed the decision, saying that the adoption was not proper anta heli they did not, ಅವನ ರೈಟ್ ಏನು ಡಿಕ್ರಿ ಆಗಿತ್ತು ಅದನ್ನು ರಿವರ್ಸ್ ಮಾಡ್ತಾರೆ. ಸೊ there he goes in appeal to the Supreme Court. The Supreme Court says that if the appellate court has to interfere with the findings or fact, then if the appraisal of the evidence of the trial court is based on some misunderstanding of the evidence or not, whether the trial court has looked into evidence properly, whether inadmissible evidence has been recorded, all these things can be known if reasons are given for the decision. Without giving reasons, they cannot look into that. Secondly, the appreciation of evidence also has to be done by the higher court, because if it cannot change the evidence. Here in this case, the court changes the decisions, so it cannot change the decision unless it cannot change the finding unless the whatever the decision is given by the lower court, it comes to know that it is not according to law. ಕಾನೂನು ಪ್ರಕಾರ ಇಲ್ಲ ಅಂತ ಹೇಳಿದರೆ ಮಾತ್ರ ಅದನ್ನು ಚೇಂಜ್ ಮಾಡೋಕ್ಕೆ, ರಿವರ್ಸ್ ಮಾಡೋಕ್ಕೆ ಅದಕ್ಕೆ ಹೈಕೋರ್ಟ್ಗೆ ಒಂದು ಪವರ್ ಇರುತ್ತೆ, ಇಲ್ಲ ಅಂದರೆ ಈ ಪವರ್ ಚಲಾಯಿಸೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳುತ್ತೆ. ಸೊ ಇನ್ ದಿಸ್ ಕೇಸ್ there are some other duties also along with these duties. Of course, appellate court has to look into several facts when it comes to the appeal. So an appellate court shall not dismiss an appeal in limine which raising triable issues. So in limine, when it dismisses, that is at the outset, appeal ಬಂದಾಗ at the outset ಮೊದಲನೇದಾಗಿ ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿಬಿಟ್ರೆ ಅದರಿಂದ ಇಶ್ಯೂಸ್ ಕ್ರಿಯೇಟ್ ಆದರೆ, ಬಿಕಾಸ್ ಆಫ್ ದ್ಯಾಟ್ ದೇರ್ ಆರ್ ಯಾವುದೇ ಇಶ್ಯೂ ಇದೆ ಅದನ್ನು ರಿಪ್ಲೈ ಮಾಡಿಲ್ಲ, ಆಗ ಅದು ಸರಿಯಾಗಿ ಅಪೀಲ್ ತಗೊಳ್ಳೋಕ್ಕೆ ಆಗಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು. ಅಂದರೆ ಪೂರ್ತಿ ಆ ಇಶ್ಯೂಸನ್ನು ನೋಡಿ ಅದನ್ನು ಒಂದೇ ಸತೆ ಕೊನೆಗೊಳಿಸಬೇಕು, ಅದನ್ನು ಮುಂದೆ ಕಂಟೆನ್ಷನ್ಸ್ ಇಡಬಾರ್ದು. ದಟ್ ಈಸ್ ದ ಡ್ಯೂಟಿ ಆಫ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್. ಇಟ್ ಶುಡ್ ನಾಟ್ ಕೀಪ್ ಇಟ್ ಫಾರ್ ಟ್ರಯಬಲ್ ಇಶ್ಯೂಸ್. Secondly, it cannot dismiss any appeal partly, or it cannot admit an appeal partly. It has to admit an appeal as a whole. We said that sometimes when a respondent, even he is in favor of a decree also, he can appear. We were discussing when we spoke about the judgment of the first appellate court must be supported. Suppose the first appellate court has given a judgment and it has given a findings on any issues which comes to appeal, then that judgment must be supported on findings, not on other things, because when it comes for the second appeal, the findings of the issues cannot be questioned. That is the duty of the second appellate court, to see that the findings on all the issues by the first appellate court are supported. ಮೊದಲನೇ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಏನಿದೆ, ಎರಡು ಅಪೀಲ್ಸ್ ಇರುತ್ತೆ. ಫಸ್ಟ್ ಅಪೀಲ್ ಆದಮೇಲೆ ಸೆಕೆಂಡ್ ಅಪೀಲು ಇರುತ್ತೆ, ಅದನ್ನು ನಾವು ನೆಕ್ಸ್ಟ್ ಚರ್ಚೆ ಮಾಡ್ತೀವಿ. ಸೊ ಎರಡನೇ ಅಪೀಲಲ್ಲಿ ಫಸ್ಟ್ ಅಪೀಲಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ, ಆ ಅಪೆಲೇಟ್ ಕೋರ್ಟರ ಫೈಂಡಿಂಗ್ಸ್ ಏನಿದೆ ಅದನ್ನು ಕ್ವೆಶ್ಚನ್ ಮಾಡಬಾರ್ದು, ಸಾಮಾನ್ಯವಾಗಿ ಕ್ವೆಶ್ಚನ್ ಮಾಡಬಾರ್ದು. ದೆನ್ ಇಟ್ ಶುಡ್ ನಾಟ್ ರಿಸ್ಟೇಟ್ ದ ಎವಿಡೆನ್ಸ್. ಒಂದೇ ಸತಿ ಎವಿಡೆನ್ಸನ್ನ ಏನು ಹೇಳಿದ್ದಾರೆ ಅದನ್ನು ಮತ್ತೆ ಸ್ಟೇಟ್ ಮಾಡಬಾರ್ದು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಆಸ್ ವಿ ಸ್ಪೋಕ್ ಅಬೌಟ್ ದ ಕೇಸ್ ವೇರ್ ದ ಅಡಾಪ್ಷನ್ ವಾಸ್ ಕ್ವೆಶ್ಚನ್, ದ ಹೋಲ್ ಪ್ರೊಸೀಜರ್ ಆಫ್ ಅಡಾಪ್ಷನ್ ವಾಸ್ ರೀಸ್ಟೇಟೆಡ್ by the court, by the appellate court, which is not the duty of the court. It cannot take up the evidence and create a different kind of evidence. So it cannot, if it agrees with the conclusion of the trial court. Of course, conclusion of the trial court ಗೆ ಅಗ್ರಿ ಮಾಡಿಲ್ಲ ಅಂತಂದರೆ ಆಗ ಈ ಎವಿಡೆನ್ಸ್ ಸರಿಯಾಗಿ ತಗೊಂಡಿಲ್ಲ ಅವರು ಅಂತ ಹೇಳಿ ಅದನ್ನು ನೋಡ್ಕೋಬೋದು. ಸೊ ವಾಟ್ ಈಸ್ ದ ಎವಿಡೆನ್ಸ್? ಸಿ, we have seen in what conditions additional evidence can be taken by the appellate court. If it takes additional evidence on those grounds only, that is, which evidence was not produced or which the he had not an opportunity to produce even though complete care was taken, due diligence was exercised. ಪೂರ್ತಿ ಕಾಳಜಿ ತಗೊಂಡು ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಕೊಡೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂದರೆ ಅಡಿಷ್ನಲ್ ಎವಿಡೆನ್ಸ್ ತಗೋಬಹುದು ಅಂತ ಎಲ್ಲ ನಾವು ಚರ್ಚೆ ಮಾಡಿದ್ದೀವಿ. ಸೊ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಎವಿಡೆನ್ಸನ್ನು ನೋಡಿ ಅದನ್ನು ಸ್ಟೇಟ್ ಮಾಡ್ಬೋದು. ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳಿರೋ ಅಂಥ ಏನು ನಿರ್ಣಯ ಇದೆ ಆ ನಿರ್ಣಯಕ್ಕೆ ಒಪ್ಪಿದರೆ ಆಮೇಲೆ ಅದನ್ನು ಎವಿಡೆನ್ಸನ್ನು ಕನ್ಕ್ಲೂಡ್ ರೀಸ್ಟೇಟ್ ಮಾಡೋಕ್ಕೆ ಇನ್ನೊಂದು ಸತಿ ಹೇಳೋಕ್ಕೆ ಅವರ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಡ್ಯೂಟಿ ಅಲ್ಲ. ನಾವು an appellate court has to accept a statement of fact as to what transpired at the hearing in the trial court, and it should take it as if it is true, final and conclusive. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಏನು ಆಗಿದೆ ಆ ಪ್ರೊಸೀಡಿಂಗ್ ನಿಜ ಇತ್ತು, ನಿಜ ಹೀಗೆ ಆಗಿದೆ, ಅದು ಕೊನೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅದನ್ನು ಒಪ್ಕೋಬೇಕು. ಇಟ್ ಹ್ಯಾಸ್ ಟು accept a statement of fact. Whatever happens at the hearing is the first instance, court of the first instance. There all the evidence is taken. There all the witnesses come before the court, and therefore the court cannot say that this is not the position. It cannot change it. It cannot look into the whole case from the beginning. It is going to look into the decision and on what grounds the decision has been given, is it not? So the duty of the appellate court is to accept the statement of fact as final and conclusive. There is one case, State of Maharashtra versus Ramdas Srinivas Naik. In this case, I have discussed this case also earlier, where the governor's powers of discretion, whether a governor can give see, you know that when a chief minister has been questioned as having been engaged in corruption, ಇದು ಕರಪ್ಷನ್ ಕೇಸ್ ಅಂತ ಹಾಕಿರ್ತಾರೆ. ಸೊ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಮೇಲೆ ರಾಮದಾಸ್ ಶ್ರೀನಿವಾಸ್ ನಾಯಕ್ ಹ್ಯಾಸ್ ಕ್ವೆಶ್ಚನ್ on the state of Maharashtra. There is a requirement that if a chief minister has to be questioned or has to be tried before the court, then the sanction of the governor should be taken. Governor sanction ತಗೋಬೇಕು chief minister ನ ಟ್ರೈ ಮಾಡಬೇಕಾದ್ರೆ. According to that he applies for the sanction. ಆ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಳ್ಳುವಾಗ ಗವರ್ನರ್ ಏನು ಮಾಡ್ತಾರೆ, he takes the advice of the council of ministers. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಈಗ ನಾವು ಹೇಳ್ತೀವಲ್ಲ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಪ್ರಕಾರ ಗವರ್ನರ್ ಏನಾದರೂ ಮಾಡಬೇಕಾದ್ರೆ ಅವನು ವಿತ್ ದ ಏಡ್ ಆ್ಯಂಡ್ ಅಡ್ವೈಸ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ಆಫ್ ಮಿನಿಸ್ಟರ್ಸ್ ಅಂತ ಇದೆ. ಸೊ ವಾಟ್ ಎವರ್ ದ ಗವರ್ನರ್ ಡಸ್, he does with the aid and advice of the council of ministers. He is bound to ask them. That is the reason. Now the question in this case was whether when he is sanctioning the permission to sue or to complain against the chief minister before the court or to initiate criminal proceedings, sanction is asked, whether he can take the aid and advice of the council of ministers. Here what happens, if he takes the aid and advice, they are going to say in favor of the chief minister only. Chief minister favor alline ಅವರು ಕೊಡ್ತಾರೆ, ಅವರು ಅದನ್ನು ವಿರುದ್ಧವಾಗಿ ಕೊಡೋಕ್ಕಾಗಲ್ಲ council of ministers. Then where is his discretion? So this was questioned before the Supreme Court. The Supreme Court in this case said that the court has a duty, and the duty is that when there is a statement of fact and what transpired at the hearing in the lower court, it has to be admitted as true. So adu ಒಂದು. Secondly, ಈಗ ಒಂದು ಹಿಯರಿಂಗ್ ಆಗಿದ್ಮೇಲೆ when suppose the court has said that these are the facts, they have put forth the facts before the court relating to the corruption. ಎಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆ. ಕರಪ್ಷನ್ ಏನಾಗಿದೆ, ವಾಟ್ ಹಿ ಹ್ಯಾಸ್ ಟೇಕನ್ ದ ಬ್ರೈಬ್ ಫಾರ್ ವಾಟ್ ಪರ್ಪಸಸ್. ಅದು ಬಿಲ್ಡಿಂಗ್ಸ್ ಕಟ್ಟಬೇಕಾಗಿತ್ತು ಬಾಂಬೆನಲ್ಲಿ. ಸೊ ಆ ಬಿಲ್ಡಿಂಗ್ಸ್ ಕಟ್ಟಬೇಕಾಗಿದ್ರೆ ಹಿ ಹ್ಯಾಸ್ ಟೇಕನ್ ಬ್ರೈಬ್ ಅಂತ ಹೇಳಿ ಅವ್ನು ಲಂಚ ತಗೊಂಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿ ಅವ್ರ ಮೇಲೆ ಒಂದು ಕೇಸ್ ಹಾಕಿರ್ತಾರೆ. ಸೊ he gave the permission by taking some amount. That was the case. We have read about this case in the constitution also when we were studying the constitution. So there the court says that in such cases the recording of reasons is important. ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿರಲ್ಲ, ರೀಸನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿರಲ್ಲ, ಇದು ಹಾಗೆ ತಗೊಂಡಿರ್ತಾರೆ. ಸೊ ಅದರಿಂದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅ ಡ್ಯೂಟಿ ಟು ಅಪ್ರಿಷಿಯೇಟ್ ದ ಎವಿಡೆನ್ಸ್ ವಿಚ್ ಹ್ಯಾಸ್ ಕಮ್ ಬಿಫೋರ್ ದ ಲೋವರ್ ಕೋರ್ಟ್, ಆ್ಯಂಡ್ ದ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಸಿ ದ್ಯಾಟ್ whatever findings has been put forth by the lower court has to be taken as a true fact, and it should be final. ಇದನ್ನು ಹೇಳಿದ್ದಾರೆ. Now this is the duties, these are all the duties of the appellate court. Now coming to the last part of the function of the high court, or the appellate court. It may be the High Court or it may be the Supreme Court. So, what is the judgment? Section 98 speaks about the contents of the judgment, the requirements of the judgment. First of all, it says that if an appeal is heard by a bench of 2 or more judges, appeal hear ಮಾಡೋಕ್ಕೆ ಒಬ್ಬರು ಜಡ್ಜ್ ಇರ್ಬೋದು, 2 or more judges ಇರ್ಬೋದು ಇರುವಾಗ, then it must be decided in the accordance with the opinion of the majority of the judges. A majority decide ಮಾಡಬೇಕು ಇದನ್ನು. So, suppose there are more judges, there should be a majority. Suppose the judges are a even number, 2 judges ಇದ್ದಾರೆ, then they should take the opinion of a third judge and decide if they dissent. If both agree, then there is no question of dissenting. ಇಬ್ಬರು ಜಡ್ಜಸ್ ಇದ್ದಾರೆ, ಇಬ್ಬರೂ ಅದೇ ಪಾಯಿಂಟ್ಗೆ ಬಂದರೆ, ಅದೇ ಡಿಸಿಷನ್ ನಿರ್ಣಯಕ್ಕೆ ಬಂದರೆ, ಆವಾಗ 3ನೇ ಜಡ್ಜ್ಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. But if it is 2 judges and they dissent from each other, then they should appoint a third judge. Here there is one case, Sikkim Subba Associates versus State of Sikkim. ಇದು ಸಿಕ್ಕಿಂ ಸುಬ್ಬಾ ಅಸೋಸಿಯೇಟ್ಸ್ ಅಂತ ಒಂದು ಅಸೋಸಿಯೇಷನ್ ಆಫ್ ಸಿಕ್ಕಿಮಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದನ್ನು ಒಂದು ಅಸೋಸಿಯೇಷನ್ ಮಾಡಿರ್ತಾರೆ. ಅದರಲ್ಲಿ ಅವರು ಲಾಟ್ರೀಸ್ ನಡೆಸ್ತಾ ಇರ್ತಾರೆ. ದೇ ಆರ್ ರನ್ನಿಂಗ್ ಲಾಟ್ರೀಸ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ದ ಅಸೋಸಿಯೇಷನ್, ವಿಚ್ ಈಸ್ ಇಲ್ಲೀಗಲ್. But they say that this is they take the money for the purpose of the fund of the association. That is a fact. Here they appointed 2 judges for this purpose. It came before the appeal in this case, whether the lottery was taken and the facts whatever was there according to that the case. It came before a bench of 2 judges. The 2 judges did not agree with the decision of the lower court, and therefore it goes in, they appoint a third judge in appeal. So the third judge was transferred. As soon as he was appointed, he was transferred. He was not there to sit over the judgment. So the appeal was decided. Now the associates go to the state of Sikkim goes in appeal, and in appeal the Supreme Court says in this case that if there is a judge who has been appointed and he for some reason he is not able to carry on the proceeding, it should be kept pending for another judge or for that judge to come back. If there is a dissent, then it must be decided by the question is under section 98, it should be decided by majority. So if it is majority, then there has to be an odd number and the third person has to be waited for. ಅವ್ರನ್ನ ವೇಟ್ ಮಾಡಿ ಅಥವಾ ಪೆಂಡಿಂಗ್ ಇಟ್ಬಿಟ್ಟು ಅದನ್ನು ಡಿಸೈಡ್ ಮಾಡಬೇಕು. ಬೈ ದ ಹರಿ ವಿಚ್ ದ appeal was disposed of is not proper. So if there is a majority of judges, there has to be 2 people, or there should be if they don't agree, there has to be a third person. Where there is no majority concurring in a judgment, varying or reversing the decree shall be confirmed. ಮೆಜಾರಿಟಿನೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಅದರಲ್ಲಿ ಮೆಜಾರಿಟಿ ವೇರಿ ಮಾಡೋಕ್ಕೂ ಮೆಜಾರಿಟಿ ಇಲ್ಲ, ರಿವರ್ಸ್ ಮಾಡೋಕ್ಕೂ ಮೆಜಾರಿಟಿ ಇಲ್ಲ. ವೇರ್ ಇಟ್ ಈಸ್ ಕನ್ಕರಿಂಗ್ ಮಾಡೋಕ್ಕೆ, ಅದನ್ನು ಜಜ್ಮೆಂಟ್ ಸರಿ ಅಂತ ಹೇಳೋಕ್ಕೆ ಮೆಜಾರಿಟಿ ಇಲ್ಲ ಅಂತಂದರೆ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬೋದು ಆ ಡಿಕ್ರಿನ. ದೆನ್ ವೆನ್ ಈವನ್ ನಂಬರ್ ಆಫ್ ಜಡ್ಜಸ್ ಡಿಫರ್ ಆನ್ ದ ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ, ದೆನ್ ದೇ ಮಸ್ಟ್ ಸ್ಟೇಟ್ ದ ಪಾಯಿಂಟ್ and the appeal will be heard by 1 or more judges and decided according to the majority. Both the judges, if they differ on the point of law, they will state the point of law, and the third judge is going to decide. He is not going to decide, but he will also put his point of law, and then according to the majority it will be decided. Then Rule 30 says that after hearing the parties or their pleaders, the appellate court shall pronounce the judgment in the open court. Then this may be at once or at a future date, and the notice should be given to the lawyers or the parties and to their lawyers or pleaders. Now the judge need not read out the whole judgment, he can only read out the final order. This is stated in Rule 30. But at the time of the judgment, when the judgment is pronounced, immediately afterwards a copy of the judgment must be made available for the parties or the pleaders to look into. They have to be given an opportunity to peruse the judgment. ತಕ್ಷಣ ಜಜ್ಮೆಂಟ್ ಆದ ತಕ್ಷಣ ಕಾಪಿ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್ಸು ಇಬ್ಬರಿಗೂ ಕೊಡಬೇಕು, ಪಾರ್ಟೀಸ್ಗೆ ಮತ್ತು ಪ್ಲೀಡರ್ಸ್ಗೆ ಕೊಡಬೇಕು. ಸೊ ಅದರಲ್ಲಿ ಏನು ಕಂಟೆಂಟ್ಸ್ ಇರಬೇಕು ಜಜ್ಮೆಂಟಲ್ಲಿ? ವಾಟ್ ಆರ್ ದ ಕಂಟೆಂಟ್ಸ್ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್ಸ್ ಅಂಡರ್ ರೂಲ್ 31? ಫಸ್ಟ್ ಆಫ್ ಆಲ್, ಇಟ್ ಶಾಲ್ ಬಿ ಇನ್ ರೈಟಿಂಗ್. the judgment of the appellate court shall be in writing. It shall state the points for determination. ಯಾವ ಪಾಯಿಂಟಲ್ಲಿ ನಿರ್ಣಯ ತಗೋಬೇಕು ಆ ಪಾಯಿಂಟ್ಸ್ ಇರಬೇಕು ಜಜ್ಮೆಂಟಲ್ಲಿ, ಅದರಲ್ಲಿ ಇರೋ ನಿರ್ಣಯ ಇರಬೇಕು. ದ ಡಿಸಿಷನ್ ಆನ್ ದೋಸ್ ಪಾಯಿಂಟ್ ಶುಡ್ ಬಿ ದೇರ್. ದ ರೀಸನ್ಸ್ ಫಾರ್ ದ ಡಿಸಿಷನ್ ಶುಡ್ ಬಿ ದೇರ್. ಆ ಡಿಸಿಷನ್ ನಿರ್ಣಯ ತಗೊಳ್ಳೋಕ್ಕೆ ಕಾರಣ ಏನು, ಆ ಕಾರಣಗಳು ಅದ್ರ ಜೊತೆಲೇ ಇರಬೇಕು. ಯಾವುದೇ ಡಿಕ್ರಿ ಅಪೀಲ್ ಆಗಿರುವಂಥ ಡಿಕ್ರಿ ರಿವರ್ಸ್ ಆಗಿದ್ರೆ, ಉಲ್ಟಾ ಆಗಿದ್ರೆ, ಅಥವಾ ಡಿಫರೆಂಟ್ ಆಗಿದ್ರೆ, ಬೇರೆ ಆಗಿದ್ರೆ, then if it is reversed or varied, then the relief what is given to the appellant should be stated in the judgment. ಯಾವ ಪರಿಹಾರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪೀಲ್ ಮಾಡಿರೋನಿಗೆ ಅದನ್ನು ಸ್ಪಷ್ಟವಾಗಿ ಅದರಲ್ಲಿ ಕೊಡಬೇಕು. ಅವನಿಗೆ ಯಾವುದರ ಪರಿಹಾರದ ಮೇಲೆ ಹಕ್ಕಿದೆ ಆ ಪರಿಹಾರ ಸ್ಟೇಟ್ ಮಾಡಿರಬೇಕು. ದೀಸ್ ಆರ್ ದ ಡಿಫರೆಂಟ್ ಕಂಟೆಂಟ್ಸ್, 5 ಕಂಟೆಂಟ್ಸ್ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್. This judgment shall be signed and dated by the judge or the judges concurring therein. Where the appeal is heard by more judges than one, suppose it is heard by 2 or more judges, rule number 34 says, if in that judges any judge dissents, dissent means he does not agree with the majority decision, suppose he dissents. So for example, there are 2 people who agree with the trial court's decision. One judge does not agree with the trial court decision. He is a dissenting judge. So ಯಾವ ಜಡ್ಜ್ ಅದರಲ್ಲಿ ಅಗ್ರಿ ಆಗಲ್ಲ, he shall state in writing the decision which he thinks should be passed. ಅವನ ಮತದಲ್ಲಿ ಏನು ಡಿಸಿಷನ್ ಆಗಬೇಕಾಗಿತ್ತು ಅದನ್ನು ಸ್ಟೇಟ್ ಮಾಡಬೇಕು, ರೈಟಿಂಗಲ್ಲಿ ಹೇಳಬೇಕು, ಬರವಣಿಗೆಯಲ್ಲಿ ಅವ್ರು ಹೇಳಬೇಕು. ಮತ್ತು ಅದಕ್ಕೆ ಕಾರಣಗಳನ್ನು ಹೇಳಬೇಕು. ಇಫ್ he is a dissenting judge, he has to give the whole decision what he would have given and the reasons for the same. In as an see, though he does not agree, it becomes a part of the judgment. You must have studied the dissent of Justice Khanna, which became very famous in the fundamental rights case. I think you remember that, where whether it is a fundamental right, right to assembly, speech and expression was questioned before the Supreme Court, and the question was whether the right can be suspended, right to life, whether it can be suspended at the time of emergency. So at that time one judge dissented, that is Justice Khanna dissented, saying that right to life cannot be taken away even during the emergency. The other judges said that President has a power to suspend all the rights, so all the rights, fundamental rights, can be suspended during emergency. There Justice Khanna's judgment came as a dissenting judgment, but later on in the further cases this dissenting judgment was approved by the court, and later on it led to a amendment to the constitution. There according to the constitution, the president cannot suspend right to life, that is article 20 and 21. 20 is relating to the rights of the convicts, and right of the convicts and the person who is convicted, and also relating to right to life under 21. So judgment dissenting ಇದ್ರೂ ಅದಕ್ಕೆ ಒಂದು ಇಂಪಾರ್ಟೆನ್ಸ್ ಇರುತ್ತೆ. ಅದರಿಂದ ಆ ಡಿಸೆಂಟಿಂಗ್ ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗಲ್ಲಿ ಬರಿಬೇಕು, ಅದನ್ನು ರೀಸನ್ಸ್ ಕೊಡಬೇಕು ಅಂತ ಅವಶ್ಯಕತೆ ರೂಲ್ 34 ಪ್ರಕಾರ ಇದೆ. ಸೊ ದಿಸ್ ಈಸ್ ಅಬೌಟ್ ಜಜ್ಮೆಂಟ್. ನಾವು ಲುಕಿಂಗ್ ಇನ್ ಟು ದ ಡಿಕ್ರಿ. ಡಿಕ್ರಿ ಯಾವ ರೀತಿ ಬರುತ್ತೆ ಅಂತಂದರೆ, ವಾಟ್ ಈಸ್ ದ ಫಾರ್ಮ್ ಆಫ್ ದ ಡಿಕ್ರಿ? ಡಿಕ್ರಿ ಶುಡ್ ಸ್ಟೇಟ್ ದ ಡೇಟ್ ಆನ್ ವಿಚ್ ದ ಜಜ್ಮೆಂಟ್ ವಾಸ್ ಪ್ರೊನೌನ್ಸ್ಡ್, ದೆನ್ ದ ನಂಬರ್ ಆಫ್ ದ ಅಪೀಲ್, then the name and descriptions of the appellant and the respondent, then clear specifications of the relief granted in the judgment. ಯಾವುದು ರಿಲೀಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನು ಕ್ಲಿಯರ್ಲಿ ನಿರ್ದಿಷ್ಟವಾಗಿ ಹೇಳಬೇಕು, ಅಥವಾ ಅದ್ರ ಜೊತೆಲೇ ಬೇರೆ ಏನಾದರೂ ನಿರ್ಣಯ ಕೊಟ್ಟಿದ್ರೆ ಅದನ್ನು ಹೇಳಬೇಕು. ಇಟ್ ಆಲ್ಸೋ ಸ್ಟೇಟ್ಸ್ ದ ಅಮೌಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಇನ್ಕರ್ಡ್ ಇನ್ ದ ಅಪೀಲ್, ಏನು ಕಾಸ್ಟ್ ಆಗಿದೆ ಅದನ್ನು ಹೇಳಬೇಕು. ದೆನ್ ಬೈ ಹೂಮ್ ಆರ್ ಫ್ರಮ್ ವಾಟ್ ಪ್ರಾಪರ್ಟಿ ದಟ್ ಕಾಸ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ರಿಕವರ್ಡ್, ಯಾವ ಪ್ರಾಪರ್ಟಿಯಿಂದ ಆ ಕಾಸ್ಟ್ ತಗೋಬೇಕು, ಯಾವ ಪ್ರಪೋರ್ಷನಲ್ಲಿ, ಯಾವ ಇದರಲ್ಲಿ ಪ್ರಮಾಣದಲ್ಲಿ ಆ ಕಾಸ್ಟನ್ನು ಕಟ್ಟಬೇಕು, ಯಾವ ಪ್ರಾಪರ್ಟಿಯಿಂದ ತಗೋಬೇಕು ಅಂತ ಅದನ್ನು ಹೇಳಬೇಕು. ಸೊ ದ ಡಿಕ್ರಿ ಹ್ಯಾಸ್ ಟು ಕಂಟೈನ್ ಆಲ್ ದೀಸ್ 6 ಪಾಯಿಂಟ್ಸ್. ಓಕೆ, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಫಾರ್ ದ because this is the form of the decree. It has to contain these things. Under Rule 35 it is stated. And then finally the decree shall be signed and dated by the judge or judges who has passed it. The dissenting judge need not sign the decree. ಡಿಕ್ರಿಯನ್ನು ಸೈನ್ ಮಾಡಬಾರ್ದು, ಜಜ್ಮೆಂಟನ್ನು ಸೈನ್ ಮಾಡಬೇಕು. ಜಜ್ಮೆಂಟಲ್ಲಿ ತನ್ನ ಡಿಸೆಂಟನ್ನು ಹೇಳಿ ಅದನ್ನು ಯಾವ ಜಜ್ಮೆಂಟ್ ನಾನು ಕೊಡ್ತಾ ಇದ್ದೆ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ ರೀಸನ್ಸ್ ಕೊಡಬೇಕು. ಆದರೆ ಡಿಕ್ರಿಯಲ್ಲಿ ಸೈನ್ ಮಾಡೋದು ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಇಟ್ ಈಸ್ ನಾಟ್ ನೆಸೆಸರಿ. ದೆನ್ Rule 36 and 37 speaks about copies to be given. So the party should be given the certified copies and at their own expense when they apply to the appellate court. And this copy will be sent to the trial court which has passed the decree, or the court which has passed the decree from where it has gone in appeal. That copy will be given. That will be filed with the original proceedings in the suit. And the entry will be given about the judgment in the register of civil suit, so that they will know that in appeal what has been decided. That judgment goes to the lower court also. So that lower court will record that in the register of civil suits. This is the requirement under Rule 36 and 37. So what are the key points which we discussed today? First of all, we discussed what are the duties of the appellate court. We said that they are laid down by the court and also by the different judgments which we discussed about the Supreme Court judgments. Then we said that under 41, Order 41, Rule 30 to 37, the whole procedure of the judgments and decrees have been specified, and we looked into that in detail. These are the things which we discussed today. So when we summarize our discussion of today, we can say that the powers of the appellate court are not absolute and uncontrolled. The code provides for duties of the appellate court also, which should be observed. If they do not observe their duties, in the next appeal, the Supreme Court can strike down that decision, saying that the appellate court has not done its duty. Yes, so these are the observations which we will leave today, and the next session we will come to second appeals. As I said, after a first appeal, you can go in second appeal on certain conditions. ಸೊ ಯಾವ ಕಂಡೀಷನಲ್ಲಿ ಎರಡನೇ ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು ಅದನ್ನು ನಾವು ನೆಕ್ಸ್ಟ್ ಸೆಷನಲ್ಲಿ ನೋಡೋಣ. ಸೊ ಎನಿ ಕ್ವೆಶನ್ಸ್ ಅಬೌಟ್ ದಿಸ್, ಪ್ಲೀಸ್ ರೇಸ್ ಯುವರ್ ಕ್ವೆಶನ್ಸ್, ಸ್ಪೀಕ್ ಅಬೌಟ್ ಯುವರ್ ಕ್ವೆಶನ್ಸ್, ವಾಟ್ ಎವರ್ ಡೌಟ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ರೇಸ್ಡ್. ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಕಸ್ಡ್ ಅ ನಂಬರ್ ಆಫ್ ಕೇಸಸ್ ಟುಡೇ wherein we have discussed the duties of the appellate court. Any questions? Yes. So I take it that there are no questions. You can type your questions, or you can say that there is no questions. You can type that there is no questions. At least I will know that you have understood the topic and you have looked into the things which we have discussed today. ಇವತ್ತಿನ ಡಿಸ್ಕಷನಲ್ಲಿ ಏನು ಪಾಯಿಂಟ್ ಇದೆ, ಸಿ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಕಸ್ ಯೆಸ್ಟರ್ಡೇ, ದಟ್ ಈಸ್ ದ prior class where relating to the powers and duties, powers of the High Court and duties of the High Court, or duties of the Appellate Court, not High Court, duties of the Appellate Court. So this is a independent question which could appear in the examination relating to the duties and powers. So we have to state all the powers in this order, again all the duties in this order. You can refer to the questions, we can refer to the cases. Any doubt is there, please share, please write the comments, or please write your questions and you can post it in the comments, which I will be replying, and we can have a different session for that purpose. Also, please share it with anybody who are interested in this, so that they will be taking benefit of the classes or of the discussions which we have here. Okay, thank you.